This courtroom exchange starts off calmly, but it quickly turns into a battle of legal beliefs. A confident sovereign citizen appears before Judge Perkins to fight multiple traffic violations in Michigan, including driving without registration, without insurance, and without a valid license. Instead of focusing on the facts of the case, he launches into complex legal terminology, arguing that no crime has been committed because there is no corpus delicti. No injured person, no damaged property. According to him, without a victim, there can be no crime. He goes even further, questioning the court's jurisdiction and implying that the judge has no lawful authority over him. At one point, he references his own legal research, clearly convinced that his understanding of the law gives him the upper hand. But Judge Perkins remains composed and methodical. The judge explains that this is a criminal matter, not a civil one, and that traffic violations are statutory offenses under Michigan law. Whether or not there is a visible victim does not erase the fact that driving without proper registration, insurance, or a valid license is against the law. Public roadways come with legal responsibilities, and those laws apply to everyone. Still standing firm in his beliefs, the defendant requests a jury trial, confident that a jury will see things his way. The judge grants the request and schedules the dates, but not before offering a clear warning: the legal arguments he's relying on are unlikely to succeed in front of a jury. What unfolds is a powerful reminder of the clash between internet legal theories and actual courtroom procedure. Confidence alone doesn't override established law, and this defendant may soon learn that the hard way.
Give you a $0 bond. And I'll recall it once. What is your motion, sir?
I have a motion to strike and dismiss.
What are the bases?
Basis of federal rules of civil procedure. Number one, there's no claim. There's no ratification of the claim.
There is a claim. There is a. Do you want me to read out I waived the reading of the information. You want me to read the allegations that have been made into the record? Do you need me to do that?
No, I don't. No, I don't, Your Honor.
I deny your motion on that basis. What else do you have to say? What else?
You deny my motion because of what, Your Honor?
Yes.
There is no real.
I denied your motion because there is a and this is criminal procedure, not civil procedure. But I denied your motion because there is an allegation here.
You're saying, Your Honor, you're saying this is a criminal matter?
Yes.
Okay, well then we need the corpus delicti. And so that's what I'm asking for. If there was a criminal matter, basically what you're telling me is that something has happened, someone has either been damaged or someone has been or either someone has been damaged or someone has something has been come up missing. And if that's the case, then that means that there is a crime. And if there's a crime, then there is the what do you have that's saying that I did the crime? What you're saying that I created this crime that hurt this person, and if I hurt this person and I created the crime, then a third thing that you have to have is the identification of a person saying that they were hurt or damaged, or the crime that's saying what I did to hurt or damage the person. So how do you have a crime?
Okay. You went to law school?
No, Your Honor, I have not.
And where did you get that? Where did you get that from? Where did you learn all that?
I've been studying for quite some time, trying to understand what's going on. I have a different perspective as to what's being said that happened. I'm understanding more necessary for a crime to go for them to bring a crime forward. I'm understanding that a bit more.
And where did you get that understanding?
I've done some Cornell law studies. I've also sat down with a couple of friends who have had some issues. I picked up wherever I could, just started to study the law. I just started to go back through Cornell law, started to figure out what was going on, and to understand the nature of how what a crime is, and everything else. So just a
And
course of me
Cornell
searching
law,
it out.
and you're citing Cornell law for all of that you just said to the court?
No, what I did, Your Honor, was I realized that one of the biggest portions that you have to have is you have to have the that is in and that is in when you're being charged criminally.
What is a corpus delicti?
What do you mean? What is the corpus delicti?
What is your understanding of what corpus delicti is?
That is the corpus delicti is the law that's saying that there is a crime that's being committed. So in order to do that, you have to show the corpus delicti, which is you saying this is what happened. This is how this person was damaged.
So,
there is no
the
person.
Officer on this day, on these dates, because I got a lot of them, said that
I object. I object. The officer works.
Don't interrupt me.
I apologize, Your Honor. I apologize, Your Honor. My apologies.
The officer says that you drove a vehicle that wasn't registered and wasn't titled, or titled and or untitled, that you drove without a valid driver's license, that you drove without valid insurance. Again, on a different occasion, they allege that you drove without a valid driver's license and no insurance. And then on a different occasion, they allege that you drove without unregistered or untitled, or both, and drove without a valid driver's license, repeat offender, that you failed to have a trailer plate, and that you failed to secure a load on your vehicle. And on another occasion, on the same occasion that you failed to secure, that they allege you failed to secure the load, failed to have a trailer plate on your vehicle, that you didn't provide a valid driver's license. So those are the crimes. And in the state of Michigan, whether you agree or not, they are crimes. So based on your motion and all of that stuff you talk about, corpus delicti and things like that, the court denies the motion. Okay, based on those reasons that I just said. Now, how do you want to move forward? Because wait a minute, I'm not finished.
My apologies, Your Honor.
How do you want to move forward? Because in my experience, someone that comes into court, as you do, you do not want to take an offer. You do not believe that you need to have plates or registration or insurance. And you just disregard all of that portion of the law. And either you are going to move forward by having a trial, or you're going to take a deal. What do you want to do, sir?
Your Honor, first I want to put my objection on the record. And at that point,
whatever your objection is noted. What do you want to do, sir? Do you want a trial? You have two options: trial, or you want to take a deal.
Your Honor, I request a jury trial.
A jury trial.
A jury trial, yes, Your Honor.
Mr. Gray, and you can choose to answer it or not.
Yes, Your Honor.
But what I surmise and what I've heard, and I don't know if you're alleging the same thing, is that and you basically did allege the same thing, that no crime has been committed because no person has been the people of the state of Michigan are in danger of you driving without the proper documentation or anything like that. But I don't, and I'm gonna surmise, and you can correct me if I'm wrong, that you're gonna say that there's no jurisdiction to be able to pull you over because no one has been injured. Is that correct?
I think that what I'm saying is that the city of Detroit had an officer pull me over to say that you're not following these rules. And my stance is, okay, well, then that's fine. If we're following rules, then freedoms are lost. So that is that is the way that I proceed, to say, okay, well, then if we're playing cards and we play and show me yours, if this is your hand, then this is mine. and let's proceed accordingly to the law. That's it. That's my only standing is if someone doesn't stand up every once in a while and define the edges, then they all disintegrate and people lose rights.
And you know something? With that being said, I would agree with you 1,000%. That's why I pride myself, and I hope I'm doing a good job for the citizens that come in here and the police, for that matter, and the prosecution, that I am calling the balls and strikes right. And if something doesn't proceed as it should, then I will dismiss the case one way or the other. But in my short time on this bench and in my time at practicing law as a defense attorney, I get this, they can't pull me over. I've heard the corpus delicti, first time the civil procedure has been thrown at me. But from the way I see it, is that you just don't feel that the police have a jurisdiction to pull you over for these issues. Is that correct?
Do I have Your Honor, what I feel is that if we are following rules, I have to follow the rules, and every person out there, all of these officers, everybody else has to follow the rules. So if it comes down
what I'm going to hope that you do by the time you come back on the trial date, jury trial date is going to be March the 18th, 2025.
Thank you, Your Honor.
You're probably going to have an audience because everybody follows me on these cases all the time.
I understand.
All right, and I don't know if that's what you want, but we're gonna do that.
It's not that.
March the 18th, 2025. We're gonna have a final pre-trial date. Final pre-trial. This is to you, Mr. Bowman, especially the day before on February 17th, 2025 at 8:30. So Mr. Gray and Mr. Bowman, Mr. Bowman, I need you to have all your officers appear on that date. Who's ever going to state these allegations, so that we know that we're not just summoning the people of the city of Detroit to a jury that's not actually going to go. So all parties must appear, and that can be via Zoom. And the trial is going to be in person. All right. All parties must appear on final pre-trial date and obviously on the trial date. And what I would implore you to do is you need to figure out the right game, because it doesn't sound like you're playing the right game.
I understand, Your Honor. I appreciate, first and foremost, let me say, I appreciate the dialogue. I appreciate you sitting here and engaging with me at this level. So I recognize what you're saying, and I guess it's to the table we go. So
yeah, but get your game in order, because I'm just giving you a little heads up. If you come in with that game on the jury trial date, then more than likely you'll lose, unless you can find one of those jurors or a couple of those jurors, or even all of them, to have some sympathy for you, sir.
I got a whole basis for understanding, and so if that
basis that you outlined shortly today is not.
What was flawed in my what was flawed, Your Honor? What is
we already discussed it. We already discussed it. The federal rules of civil procedure that you brought up as a motion to dismiss, not the right basis. The corpus delicti, they do have a corpus delicti. They do have a crime that they say has been committed. And if you read the MCL, the Michigan court rules, and the Michigan statutes, then you'll see those crimes outlined there. They have them on the tickets. They got the statute numbers that are on the tickets. So that's not the right basis. So you're in a whole different ball game, and you need to come on to this ball game here.
Okay. All right. Okay.
This courtroom hearing begins in a quiet, orderly way, the kind of setting where everything feels routine and predictable. The judge takes the bench, the clerk calls the case, and a man steps forward to address multiple traffic violations filed against him in the state of Michigan. On paper, the charges are straightforward: operating a vehicle without proper registration, without valid insurance, and without a valid driver's license. Normally, cases like this move quickly. But from the moment the defendant begins speaking, it becomes clear this will not be a routine proceeding. The man represents himself. He stands confidently, calm but firm, carrying the unmistakable tone of someone who believes he has uncovered something the system does not want people to understand. Instead of addressing the basic facts of the charges, he immediately shifts the discussion to legal theory. He argues that no crime has actually occurred. His reasoning centers on a concept he repeats several times: corpus delicti. According to him, without a living, injured victim or tangible property damage, there can be no crime. He speaks with certainty, as though the single phrase dismantles the entire case. The judge listens patiently. There is no interruption at first, no raised voice, no visible frustration. The defendant continues, explaining that the prosecution has failed to establish what he considers the essential element of a crime. He insists that because no individual stepped forward claiming harm, the charges are invalid. In his view, traffic violations are being treated as crimes when, according to his interpretation, they do not meet the proper legal threshold. He then pivots to jurisdiction. He questions whether the court has lawful authority over him. He implies that the state cannot simply impose statutes on him without meeting specific constitutional requirements. He references federal civil procedure rules, suggesting that the wrong legal framework is being applied. At one point, he even mentions studying legal materials connected to Cornell law, presenting this as evidence that he understands complex legal doctrine. The courtroom remains quiet as he lays out his position. It is clear he believes he is not just defending himself, but challenging the legitimacy of the system itself. When Judge Perkins begins responding, the tone remains steady and controlled. The judge explains that the defendant is misunderstanding the nature of the case. This is not a civil dispute. It is not governed by federal civil procedure. It is a criminal matter under state law. Traffic statutes are enacted by the legislature, and they define specific conduct as unlawful. Driving without registration, insurance, or a valid license is prohibited. The act itself constitutes the violation. The judge clarifies that corpus delicti does not mean what the defendant claims it means. In criminal law, the concept refers to proof that a crime occurred, not necessarily proof of a complaining victim standing in the courtroom. Many crimes do not require a private individual to suffer direct harm. Regulatory and statutory offenses exist to protect public safety and order. Operating a vehicle on public roads is considered a privilege that comes with conditions. Those conditions are written into law. The defendant listens but does not concede. He reiterates his position, emphasizing that the state has not produced an injured party. He suggests that without that element, the prosecution's case collapses. He appears convinced that the judge is overlooking a fundamental principle. Judge Perkins responds again, this time more directly. The judge explains that the defendant's interpretation is legally incorrect. Traffic laws apply to every individual who chooses to drive on public roads within the state. Registration ensures accountability. Insurance protects the public in the event of accidents. Licensing verifies competency. These are not optional guidelines, they are enforceable statutes. There is a subtle shift in the atmosphere. The exchange is no longer just procedural. It becomes a clash between ideology and established law. The defendant continues pressing jurisdictional arguments. He questions the authority of the court. He suggests that statutory law cannot override certain constitutional principles as he understands them. The judge methodically dismantles each claim. He explains that state courts have subject matter jurisdiction over criminal traffic offenses committed within the state. The charges have been properly filed. The defendant has been properly summoned. The legal process is valid. Despite the explanations, the defendant remains firm. He insists that he does not consent to the court's authority. He implies that consent is required for jurisdiction. The judge clarifies that personal consent is not what establishes criminal jurisdiction. When a person operates a vehicle within a state's borders, they are subject to that state's traffic laws. Participation in public roadways carries legal obligations. The discussion continues, with the defendant returning repeatedly to the absence of a victim. He frames traffic enforcement as an overreach. The judge counters by explaining that public safety laws are preventative by design. The purpose is not merely to punish harm after it occurs, but to reduce the risk of harm in the first place. As the hearing progresses, it becomes clear that neither side is persuading the other. The defendant speaks with unwavering confidence. The judge responds with statutory references and established legal reasoning. The contrast is striking. One side relies on interpretation drawn from alternative legal theories often circulated online. The other relies on codified law and courtroom precedent. Then comes a significant moment. The defendant demands a jury trial. He states clearly that he wants a panel of citizens to hear his arguments. There is a sense that he believes ordinary people will better understand his perspective than the court does. Judge Perkins grants the request without hesitation. The right to a jury trial is fundamental in criminal cases. A pre-trial date is scheduled. A jury trial date is set for the following month. The process will move forward. Before concluding the hearing, the judge offers a candid warning. He advises the defendant to reconsider his approach. The judge explains that the arguments presented so far are unlikely to succeed before a jury. Jurors will be instructed on the law as written, not on alternative interpretations that conflict with established statutes. The judge emphasizes that the defendant would benefit from understanding how the law is actually applied in practice. The defendant does not appear shaken. He stands by his reasoning. He suggests that once the case reaches a jury, the outcome may be different. The hearing wraps up, but the tension lingers. What unfolded was more than a simple traffic case. It was a direct confrontation between sovereign citizen ideology and the structure of the legal system. The defendant views himself as standing on principle, challenging what he believes to be improper enforcement. The court views the matter as a straightforward application of statutory law. The broader issue reflected in this exchange is not uncommon. Courts across the country have increasingly encountered individuals who rely on misunderstood legal doctrines. Terms like corpus delicti and jurisdictional consent are often cited without full context. In reality, criminal law operates within a framework built on legislative authority, judicial precedent, and procedural rules that have been tested repeatedly over time. Driving is heavily regulated because it affects public safety. Vehicles can cause immense harm if operated irresponsibly. Registration ties vehicles to owners. Insurance ensures financial responsibility. Licensing establishes minimum competency standards. These requirements exist not to create victims, but to prevent them. As this case moves toward trial, the central question is no longer whether the defendant believes in his arguments. It is whether those arguments can withstand legal scrutiny before a jury instructed on Michigan law. Confidence can be persuasive, but it does not override statutes. Legal terminology can sound powerful, but in a courtroom, meaning depends on context and precedent. The defendant has chosen to take his stand before a jury. The court has allowed him that opportunity. Now, the theoretical debate will meet practical application. The courtroom will once again become the setting where belief and law intersect, and where only one interpretation ultimately carries legal weight.